Hello, my name is Sherry Edmon-Oliver. Um, with case number 3, public hospital corrects impermissible disclosure of PHI in response to a subpoena. This is with HCA 322, Healthcare Ethics and Medical Law, with instructor Ken Pfeiffer. This is Jennifer versus General Hospital. It's an example of impermissible disclosure of patient health information to a third party without her explicit consent. When the hospital turned over Jennifer's PHI without a subpoena, they broke privacy rule standards, uses and disclosures required by law, and disclosures for judicial and administrative proceedings. The privacy rule standards address the use and disclosures of individuals' health informations. This is protected health information by organizations subject to the privacy rule, called covered entities. The entity here was General Hospital. This also covers the standards for individual privacy rights and the understanding and control of their own health information, how it is used and when it is used, and to whom it is distributed to. The major goal of the privacy rule is to assure that individuals' health information is properly protected while allowing the flow of health information needed to provide and promote high quality health care and to protect the public's health and well-being. This is quoted from the United States of Health and Human Services. Permitted uses and disclosures are permitted but not required to use and disclose protected health information without an individual's authorization for the following purposes and situations: to the individual, unless required for access or accounting of disclosures, for treatment, payment, healthcare operations, opportunity to agree or object, incident to an otherwise permitted use and disclosure, public interest and benefit activities, and entities may rely on professional ethics and their best judgment in deciding which of these permissive uses and disclosures to make. That means how they're going to give out and distribute or disclose PHI or the PHI of an individual. It is the covered entity, which is General Hospital's compliance duty, not the requesting attorney's legal obligation, to ensure that Section 512 provisions are met by disclosing PHI. Section 512 is a notice of requirement which discloses PHI in response to a subpoena, discovery request, or other process unaccompanied by a court order. If the covered entity receives satisfactory assurance of reasonable efforts to notify the individual who is the subject of the PHI, in this case, it was Jennifer. Satisfactory assurance means a written statement accompanying documentation showing that the request has made a good faith attempt to provide written notice to the individual that his or her PHI will be disclosed. In other words, they needed documentation, they needed Jennifer's permission in order to use or disclose her personal health information. The notice must provide sufficient information about the matter, such as the case number, court or tribunal where pending, and to allow the individual to lodge an objection. The assurance must be indicated at that time for any objections has elapsed, or that the court or tribunal has resolved any objections in favor of permitting release of the requested PHI. If the subpoena or the other request on its face documents all these elements, no supplemental documentation is required. Additionally, the privacy rules allows the covered entity itself to provide notice to the individual to satisfy the notice requirement. In other words, General Hospital could have gotten in touch with her or gotten her to sign a release for her personal health information to be disclosed to any litigating issues or to a court. Violations and penalties for disclosing her information, according to February 2009 document, can range anywhere from $100 to $50,000 for each instance and or violation. This caps off at $1,500,000. In conclusion, General Hospital had the responsibility, legally and ethically, to notify Jennifer of the disclosure of her PHI. Legally, the hospital had an obligation to make sure that there were policies in place and that all of their employees knew of and about these policies before they disclosed her documentation, her PHI. They should have also gotten documentation or a signed statement stating that they were going to disclose or share her information with another entity outside of the documented entities in the privacy rules. Legally, the hospital had an obligation to make sure that these policies were in place on how her PHI was going to be disclosed and to whom they were going to be disclosed to. Ethically, General Hospital breached the confidence of Jennifer by failing to make reasonable efforts to protect and work in the best interest of Jennifer by only releasing her PHI, her personal information that was for her direct benefit, or to the judicial authorities who had received a subpoena from a judge or a magistrate without her permission. That was the only way that they could get and disclose her information without her permission. And then and only then should her permission not be valid. However, a subpoena was not secured, and so Jennifer has the right to take any legal action that she deems is worthy against General Hospital if she feels that her personal information was unduly disclosed or distributed to anyone outside of the entities that was in their privacy rules. My references are as follows: from the Centers for Disease Control, 2003, HIPAA Privacy Rule and Public Health. It was retrieved from the cdc.gov. The United States of Justice, 2015, Conditions of Disclosure to Third Parties, retrieved from justice.gov, Conditions and Disclosure Third Parties. U.S. Department of Health and Human Services, 2017, Summary of the HIPAA Privacy Rule, retrieved from hhs.gov, HIPAA for Professionals Privacy Laws Regulations Index. Thank you.